Thanks, guys. Thank you, Jonathan. I learned a lot in the last session. Please continue when I give this presentation, adding to it like you did the previous presentation. There's much that I don't know in this area. My name is Jon Sheldon. I'm a criminal defense lawyer out of Fairfax. I got into Habeas because I did mostly death penalty cases, and my firm, we have a small firm. Right now I have 7 death penalty cases. 2 of them are at trial level, and 5 of them are at the Habeas level. Because I do a lot of Habeas, and in a death penalty case they have to be very thorough, we ended up getting a lot of these immigration cases where people, after the fact, discovered immigration consequences. So in my office, we do no immigration, we do a lot of criminal, and we do a lot of Habeas. I think one of the reasons we're here, and one of the reasons that judges struggle with Habeas cases in the Padilla context is we are combining really 3 different topics, 3 different languages, 3 different sets of books. We have immigration law, which is civil law. We have criminal procedure and criminal substantive law. And we have Habeas, which is quasi-civil and quasi-criminal. And I think still today, when you go to a judge and in the Habeas context and you say to the judge, that criminal defense lawyer should have given this specific advice to the defendant, the judge thinks to himself, the Immigration Nationality Act, like what book would I have on my shelf that would tell me that, right? And you criminal defense lawyers, many of you might not have any text on the Immigration Nationality Act on your shelf. The immigration lawyers might not have the Virginia Criminal Code, and I bet none of you have Hertz and Liebman's $800 Habeas book on your shelf. And so we have different sets of laws, and we have different language we use. We have a notice to appear. How many criminal defense lawyers know what the notice to appear is? We have IAC, that's what we always call ineffective assistant counsel on Habeas. And how many immigration lawyers know about that? And then we have an SIS, a suspended imposition of sentence. We have our own language. It's really difficult. And the challenge in a Habeas context in convincing courts is that we all can understand each other's topic. It's one thing for a criminal defense lawyer to get a complicated criminal case, immigration lawyer to get a complicated criminal case, but we're mixing our languages and our laws, and it is difficult. And still to this day, when a criminal defendant comes to me, I think, oh shit, I need to hire an immigration lawyer. I don't want to tell them what to do, you know? And honestly, most of the time I do. I go to an immigration lawyer and I say, you know, here's $500, tell me what to do. So my presentation is really going to be about, first, lowering expectations for what it is, because I find success is often beating expectations. So my expectations are to just gain some common language in immigration, criminal, and Habeas. Gain some common language and enable us to recognize issues. So when somebody comes into your office, you can start recognizing faster what the issues are and avoid the traps. There are 2 practice tips that may or may not be helpful that I thought of during the last session. One, with Farmville, I have found that they are far less evil and far more underskilled and overworked. And if I email them, I get almost anything I want every time. I email Jeffrey Crawford, and his email address, and I debated whether I should give this to you, but I will, is jcrawford at ICA it's jcrawford at ICA-farmville.com. When I have a document that my client has to sign and I need it tomorrow, I email that to Jeffrey Crawford. He prints it out, he brings it to my client in Farmville, he gets a signature, and with 1 hour, he scans it and I get it back. When I have a client who I have to speak with, and you all know that we can't call in, clients have to call us, I email Jeffrey and I say, Jeff, I'm sorry to bother you, but I really need to speak to my client today. 15 or 20 minutes later, my client calls me. So I think sometimes it's just finding the right avenues. When I need a client from Farmville for a criminal case, I have always got them, and the way that I do it is I go to a judge and I get a Habeas, I prepare a petition for writ of Habeas ad testificandum. I bring it to a circuit court judge. They have no idea what it is. I tell them, this is what it is, this is how I get them there, this is where you sign, they sign it. And the key is getting it to the right person at Farmville. There are plenty of people at Farmville that tell you no, it won't happen. You get it to everyone. You file it in the circuit court, you get certified copies, you mail it that day to Farmville, and then you start faxing it. And I got 2 fax numbers that seem to always work. You fax it, you email it, you mail it, you get it to as many people as possible, and at least the 2 times recently that I needed my client in Fairfax Circuit Court for a criminal case, I've got them there. Because I think it's really a matter of getting it to the right person. There are plenty of people at Farmville who will tell you no to lots of things, and it's really a matter of finding the people that can get done what you need. What I'm going to do is, yes?
Sorry, I think one of the problems with getting prisoners from Farmville is that you actually usually have to coordinate with the local jail authorities because the feds do not want to pay to transport the prisoner. So you're actually doing 2 things. You're working with the local jail in addition to the Farmville folks.
Yes, absolutely. That's an excellent point. I always provide it to 3 people. I provide it to a local jail. I provide it to whoever is on the immigration side, whoever I think the attorney is, and I get it to Farmville. Because the truth is, I don't know where the sticking point will be, but the local jail is going to have some responsibility at some point. So that's an excellent point.
I'll be emailing Mr. Crawford immediately about my client. What do I say if he says, "How'd you get my email address?"
Well, you're smart enough, I know, to know what to say. So, again, this is going to be too much habeas for most of you, too little for a few of you. This is not a presentation on how to do a habeas petition. It's enough to know so that when you have clients, you know where the pitfalls are. A brief history of what you won't be doing in order to help clients, because plenty of clients will raise all sorts of other potential remedies, and I'm going to tell you, not really. They're very unlikely. The duty to give immigration advice, the remedy of habeas corpus, and common state habeas issues. Just so you know, in Virginia, there are 2 courts that have jurisdiction over habeas petitions, and that's the Circuit Court and the Supreme Court of Virginia. And the Virginia Court of Appeals does not. So there is very little law. Much of what I'm going to tell you, there are no Supreme Court of Virginia cases on, and the Virginia Circuit Courts will make decisions contrary to some of the things I tell you. So it doesn't mean you can't try all sorts of things. The general problem, of course, is that a documented immigrant, somebody who is in this country, documented, pleads guilty almost always, and then thinks their punishment is over. And either later on or directly from the jail, an ICE detainer, and they're in a lot of trouble because they would much rather, most of the clients that come to me would much rather spend a significant amount of time in jail than go back to Nicaragua or wherever else they're going. Why habeas relief? It's very brief, and the reason I'm giving you a brief history is because you will hear from other lawyers and clients, what about these remedies? So very briefly, what about Auditor Corella? All you need to know is no, not anymore, not Virginia. That's it, that's all you need to know. It has, for the most part, been overtaken by statute. It will be there to fix certain mistakes, but no, you are not going to get a court. Yes, courts years ago reached such issues through Auditor Corella, no more. Through a motion. Constantly, clients will say, how about a motion to vacate, a motion for reconsideration, a motion for this? No, not that courts haven't. Courts have done it. But a court is not going to reach this issue through a motion. Quorum vobis. So quorum vobis in the 2011 case of Commonwealth versus Mars, the Supreme Court of Virginia made clear that quorum vobis is not the proper remedy. It's habeas corpus. It's not that state courts haven't reached it before Commonwealth versus Mars. They have. No more. Not in state court, but listen carefully. In federal court, quorum vobis is a good remedy for any of this. Quorum vobis has a long, specific history of avoiding the rigid finality of judgments. For some reason, Virginia, the Supreme Court of Virginia decides to do away with that, and there are many people where there are significant harms that have no remedy, and there's no way to reach them. The federal court has a completely different set of case law, and quorum vobis can be used when, for example, the habeas is not available either because the person is no longer in custody or because the statute of limitations has passed. So remember, in federal court, you're rarely out of luck if it's a federal conviction. If it's a state conviction, quorum vobis almost never. But there is, I just note, interesting language in this quorum vobis case from 2006, that the difficulty, one of the difficulties you're going to find sometimes is the client comes to you, realizes the immigration consequences far after the habeas statute of limitations has passed. There have been courts that said, no, you should run that time from when the constitutional violation was apparent. There are other habeas difficulties in Virginia with that, but I just note that, that's important. Again, quorum vobis, it's designed to avoid the rigid structures of judgment finality. There's a recent federal case. If you have a client who has a federal criminal conviction, there are a lot more remedies than in Virginia State Court. Here's a, yes?
With respect to Morris, I know there was a talk about trying to challenge that federally, but I followed up on it. Is there any chance that's going to change on a federal?
Well, there's really, it's not really, I wouldn't say it's something that could be challenged federally. It's really a matter of how Virginia views how to use habeas and quorum vobis. So I think it's possible. There's been a petition for writ of cert that's denied, which really doesn't mean anything except they didn't want to review it. It is possible, but it does seem like the type of issue where just Virginia says, this is what our remedy is. And instead of challenging it, the next step is to go to federal court and say, there is no state remedy. Virginia has been clear about that. Therefore, the federal remedy has to be broader for people with state convictions. Recently, the Fourth Circuit said, well, we're not sure that there's no remedy. There might be quorum vobis. And it just kills me. It's like, no, every court is saying there's no quorum vobis. We can't use it. The Supreme Court of Virginia couldn't have been clearer. There's no quorum vobis. There was a petition brought to challenge a state conviction in the Padilla context, and the Fourth Circuit said, well, we're not sure you were out of state remedies because there could be quorum vobis. So there is a possibility of federal remedies for people with state convictions who have no remedy in state court. But you know, one thing I'm here to tell you, and Kate would I'm sure second this, is there is a really narrow window for remedy for these problems. It's very narrow. And in Virginia, so I practice in Virginia. I'm a Virginia lawyer, but I also practice in many other states. I have cases in Kentucky. I have cases in Alabama, cases in Texas. I have cases all over. I can tell you that the finality, the idea of finality, and the idea that the courts don't want to reach back to a case that they think is over is more rigid and more strict in Virginia than anywhere I practice. It's very difficult. So a very big issue for you criminal defense lawyers and for habeas lawyers is something that happens commonly. That is the criminal defense lawyer says, "Whoa, you're not a citizen? Well, let me tell you, there really may be immigration consequences. I really got to tell you, there might be immigration consequences." And if you look carefully at the language of Padilla, it says over and over again about giving specific advice. Yet, the courts have come up with plea forms that says if you're not a U.S. citizen, there may be immigration consequences. And the courts have been, so far in habeas, somewhat sympathetic to those forms, saying, well, maybe that's sufficient. The circuit courts in Virginia have been sort of all over the place. The circuit courts in the trial or habeas courts in other states have been more forgiving. You need to give specific advice, or you need to get that specific advice from an immigration lawyer and then give it to your client. But saying may be immigration consequences, I don't think is enough. It doesn't mean we can definitely win that case on habeas. That would be a tough fought issue. But I don't think there's any reason why anybody ought to be giving vague general warnings about immigration consequences. Strickland is the basic case, Strickland versus Washington, that says that in order to be effective, you have to give reasonable advice that doesn't prejudice your client. And we're going to talk about Strickland a little bit. There's a difference, of course, between giving wrong advice and no advice, and we're going to get to that in a second. So in Padilla, the court said that it's quintessentially the duty of counsel to provide the client with available advice about an issue like deportation. So to me, that means clear. That's advice. It's not there could be. There always, when you're not assisting, could be immigration consequences. You have to give specific advice. So this is a Massachusetts case which interpreting Padilla to mean that general warnings are not sufficient because most courts have come up with plea forms that say there may be immigration consequences. And you got to realize those plea forms are really meaningless. It's the best the court can do because how can a court say anything more specific to each defendant? But it's really misleading to put that in the plea form because it really leaves the lawful permanent resident in the same position they were in to begin with, which is having no idea what the consequences are. Commonwealth versus Morris is just a cite to the 2011 case where the Supreme Court of Virginia said Habeas is the remedy. And Strickland v. Washington, this is the case you need to know about the duties to be effective. There's two prongs: deficient performance. For deficient performance, it's really what the standard is in the community. So there's a lot made about whether Padilla is retroactive, right? Padilla was decided March 31st, 2010. And suppose your client comes to you and he entered his guilty plea before that date. Now remember, the way you measure whether Padilla applies retroactively is when his direct appeal was filed. So he didn't appeal, it's the date that he was sentenced, the date the judge signed the order sentencing him, plus 30 days for the notice of appeal. And if he's before March 31st, 2010, the standard advice is Padilla doesn't apply retroactively. But Strickland versus Washington still might apply. That is, if it was the standard in your community, in the circuit court where you practice, for attorneys to give immigration advice in clear cases, then it is possible that you can convince a court properly that the defense attorney gave unreasonable advice when they failed to give immigration advice. And you would call lawyers to testify in that case. You also have to show prejudice, and prejudice in this case is the reasonable probability of a different result. When somebody pleads guilty, the reasonable probability of a different result is that the defendant would have been making a rational decision to reject the plea and go to trial instead. So the first thing is, you can't give reasonable advice if you don't know your client's immigration status. Many cases come to me where the attorney claims that they gave advice. They say, I can't remember, but I'm sure I told them there were immigration consequences. And I asked the attorney, what's the immigration status of Mr. Padilla? And the attorney says, I don't know. It's nowhere in his file. If you don't know the immigration status of your client, you can't possibly give them reasonable immigration advice. Is it enough to say there may be consequences? Possibly. There are cases that are complicated and unclear, that even an immigration lawyer would spend a long time researching and not sure what the outcome would be, I imagine. In those cases, it may be that on Habeas, the judge says there was no duty to give the immigration advice because it was too complicated. But most of our cases are clear. The vast majority of cases, and I probably get at least one a week that come to my office, are a lawful permanent resident that pleads guilty to a grand larceny with a 3-year sentence. I think in that case, every criminal defense lawyer ought to know what to say to that client. You're going to be deported if you plead to that. Can you refer them out to an immigration lawyer? I think this is an open question. I have not found any cases regarding this. If the client does hire an immigration lawyer and does get advice, that's sufficient. But if they don't, I think it's the criminal defense lawyer who's responsible for making sure they get the advice. Wrong advice. There is no retroactivity issue for wrong advice. If somebody comes to your office and says that my lawyer told me by taking this plea with 180 days I wouldn't be deported and that was wrong, then you can challenge that conviction based on Padilla, not based on Padilla at all. Before Padilla, it was still deficient performance to give wrong advice. Again, it's just based on the standard in the community. Prejudice, you have to prove that a rational client would have chosen to go to trial instead of take the plea. There's a lot of factors, and you really have to look carefully at the lack of connections with the country of origin, at the language, does your client speak the language that he's going to be sent back to, at his family connections, at his culture, at the danger of returning. Why did he come here in the first place? Is he a refugee? Was he being politically oppressed? The circumstances of the immigration. Oftentimes you'll have a client who doesn't know. They were 10 and you have to ask their parents what happened. And there's a story there that your 19 or 20-year-old client doesn't know. The local crime, the U.S. State Department has really great warnings, travel warnings, and they'll tell you all about the conditions in the host country where your client's going to be sent back to, about the crime rates and the lack of medical care. Does your client have a particular medical need that if they got sent back to Nicaragua, they could not get taken care of? If not, that is a reasonable that the judge should consider in a habeas petition of whether your client would have been willing to go to trial and take the risk of trial or just be sent back to his home country. These State Department bulletins are fantastic to learn about the conditions in the home country. And ask the client, why don't you want to go back? And you may get some reasons that there's just no way you could have thought on your own. So there are sort of really two basic requirements to file a state habeas petition. And one is that the client is detained. In federal court, we call it the custody requirement, that the client is in custody. And the second is the statute of limitations. These two topics are really quite complex. They seem simple on their face, but they can be complicated. The statute of limitations, when a client comes to you, is measured by the latest of 2 dates. It's either 1 year from the end of the direct appeal, or 2 years from the date the trial court signed the sentencing order, whichever is later. And the danger here, the trap for the unwary, is your federal habeas deadline runs 1 year from the end of the direct appeal. And so if you take a habeas client and you wait until almost the end of 2 years and your client pled guilty and you wait for 2 years and you file a timely habeas petition, you will have gotten timely for state habeas review, but you'll have eliminated his possibility for federal habeas review later. So you have to be really careful about how we use these deadlines. A common issue on detention is what kind of detention. Traditionally, 500, 600 years ago, habeas corpus was used to get people out of the sheriff's dungeons into the court. So it was literally meant the custody of the sheriff, bring him to the court so that he can get a trial. Of course, now we have it where it's more commonly used to challenge the fairness of the trial, but still this custody requirement remains. Virginia law has evolved, so they call it detention instead, and the requirement is that you can file a habeas petition challenging your detention if the order of the court granting your petition would result in the immediate release of your client. And the question is ICE custody enough? And there's very little law on the topic. The little law that there is mostly negative, but there are a couple of circuit courts, or at least one circuit court and one federal court, who have said that even though your client is not being detained on the criminal charge, being in Farmville is sufficient because the granting of the habeas petition would result in their being released from Farmville. If your eyes are glazing over, this is like as deep as I'm going to get into habeas. But your client has to be detained. And if your client walks into the office and is talking to you about a habeas petition, your first concern ought to be, oh, they're released, they're not detained. There is an exception in Virginia, and there's a statute, 801-654b3, which says a suspended sentence is also sufficient. So if your client has a 1-year sentence, suspended for a year, then they're being detained for that year. Okay.
Probation is also sufficient.
Probation.
they're on some sort of supervised probation.
So part of the point of this is we're scratching the surface. It's complicated. It can be difficult. Your eyes can glaze over. Here is an example, like Jonathan was showing you, of these warrants. We get a lot of people with misdemeanor convictions. And the two problems with a misdemeanor conviction are the statute of limitations, because a lot of times they're from 2003, 2006, and sometimes it's a detention requirement. That is, they're in my office. Of course, they only got 15 days, or in this case, 20 days of active time. I'm going to try and blow this up. So in this case, they got a jail sentence of 179 days with 159 suspended. So in this case, the person walked in my office and said, you know, here I am, I need to file a habeas petition. This conviction here, you see the judge's signature in 2009, is getting me deported. And so the question is, how long did they get? How long a jail sentence did they get for immigration purposes? Does anybody have a guess? Is that right? How long are they in detention for habeas purposes? How long is their sentence for habeas purposes? Well, the problem with this warrant and with the ones Jonathan put, except for one, is it says suspended for a period of blank. And then the judge never wrote in how long the sentence was suspended for. And by statute in Virginia, if the judge doesn't specify how long a sentence is suspended for, then your sentence is suspended for the maximum term of what you pled guilty to. So this person has a sentence of 1 year. It's 179 days with 159 days suspended for a year. That means that time is hanging over her head for a year. So for detention purposes for habeas, I would argue that habeas is available for a year. But oftentimes, in this case, she came to me well after the year. I could imagine in immigration court, if it was relevant, that they call this a 1 year sentence also, since it's suspended for a year. But I don't know the answer to that. Certainly her immigration lawyer was telling me that this was considered a 1 year sentence.
As a practical note, the judge would normally write in there for a period of 12 months or a period of 1 year. He didn't do it on that one, obviously, but I'm in misdemeanor court every day, and they always say, your sentence is suspended, conditioned upon good behavior for a period of 1 year.
Right. But I get these every single week. I get someone coming to my office, and less than half of them have that line filled out. Less than half of them have a judge saying how long the sentence is suspended for.
Just as a practical matter, how often are they coming in after, well, I guess better questions, how long after conviction are they getting MTAs? Is it within the year they just wait in the office?
I'm getting two different groups that come in my office. The first group is the group that is pleading guilty to something that's like 15 days. If 15 days is up and all of a sudden there's an ICE detainee, they're brought to Farmville and then they call me. That's one group. The other group are these people from 2003, 2006 who have just gotten a notice to appear. They're not being detained and they're in immigration proceedings. So for me, what I'm seeing is two completely different groups.
And there's no indication of when ICE or immigration is, it's just kind of random, I guess?
Yeah.
Oh, just curious.
Right.
Statute of limitations on the immigration enforcement.
So with somebody like this, who their conviction is in 2009, they're not being detained, there is something we can do with these other than the habeas corpus. If there are mistakes on the back of the warrant, you can go to the district court judge and you can say to him, look, you can go back nunc pro tunc and correct something on the warrant as long as that correction is about a matter which everybody agrees we meant something different. So if you can convince the judge that immigration court is viewing this as a 1 year sentence, the judge will agree, I did not mean a 1 year sentence. Nobody agreed. And you can go back, nunc pro tunc in general district court, and say, okay, would you just fix that? Would you put in 180 days or 179 days, whatever you thought? And we've had judges say, of course, that's what we meant, that's what I'll do, and then it can fix, in some cases, the immigration consequences. So there is this other remedy other than habeas corpus with misdemeanors in getting a judge to go back and revisit a very old conviction. Are there any questions about that? Yeah.
I'm getting confused. Are you saying now that we're supposed to make sure the period of suspension is 179 days?
What you should do is find out what you need in your conviction to avoid immigration consequences, and then make sure the warrant says that. Now, what I'm dealing with is I'm not dealing on the criminal law side, I'm dealing on the habeas side. I'm saying once something's gotten messed up.
I see. So for the 10
If this is important, if the immigration lawyer or you as the criminal defense lawyer determine that a 180-day sentence or less is important, I would absolutely make sure they say suspended for 180 days or less.
Can we get the immigration attorneys that can you answer that for the petty offense exception in a case like this? For it to qualify for the defendant, would it have to be for a period of 180 days? Because usually it's 12 months.
Correct, and I just recently had a case where somebody was, got a sentence of 12 months old suspended, and it was for petty larceny. And I had him go to a criminal attorney, and he got it suspended to 6 months for 5 months suspended.
That's not my
And that
question.
was-
No, the question is, for the sentence is 179 days, it's 159 suspended, but the period of probation is always for 12 months. So I'm trying to understand if we have to get that period of probation to be 180 days.
Not to my knowledge, I think you'll be fine with 12 months probation. It's a sentence.
But you're also talking about two different ideas. Your probation is 109 days. Probation is different than suspension of the sentence. So suspending the sentence is not being on probation, it just means, I think.
The judge could put 12 months probation over there and still done 159 days suspended. You need to look at the top part, the jail sentence and a suspension on the top.
Yeah, for petty offense, they don't count.
I think it's important that you have a 6-month sentence or less, then there's no reason not to ask judges to write in 180 days.
Well, yes, there is, because the Commonwealth is going to want him to be on supervised probation for a year. Not 6 months.
Our judges won't do that, I don't think.
I have never had, if we get 179 days with 159 suspended, I've never had a prosecutor care significantly at all about how long it's suspended for.
It's a big problem in a lot of jurisdictions here.
So that's part of what you bargain over, right?
Usually on a I-213, when what immigration gives out to see, what the criminal record is, and it says 179 imposed, 159 suspended, even if it says 12-month probation, you're fine as long as the sentence.
So I see a lot of these after the fact. Right? I don't do misdemeanors. I don't know what the practice is in misdemeanor court, and so I'm here as a habeas lawyer. But what I see is oftentimes the period that the jail sentence is suspended is for the amount of time of the jail sentence. And I think it's, every jurisdiction is different, but what you really got to take away is it's something that you got to keep your eye out for and bargain for if it's going to be important. So really what's important there is how long is the defendant in custody for purposes of subject matter jurisdiction. When the term of suspension is not indicated, this is the statute that says 19.2.306, and this is the INA section, which we had an immigration lawyer telling us, if we can get that suspended sentence, that sentence suspended for 180 days, then he can get some remedy in immigration court. A common issue in habeas challenging a conviction is convincing the court that your client would not have pled guilty. If they were told you'd be deported, you got to convince the judge that your client wouldn't have pled guilty. He would have taken the risk of trial. And the common issue is the strength of evidence. That is, many of us as criminal defense attorneys have clients who there's a video of them in the store, then they were arrested, and then they admitted to it, And then now we're coming back telling the judge, well, if he had known he'd be deported to Nicaragua, he would have went to trial. And of course, the role of the Attorney General's office is to argue that, no, he would have never taken that risk of going to trial. And so a big issue in habeas cases is what role does the strength of evidence play? And really what you need to focus on is that the harm to your client oftentimes, especially with these misdemeanors, is not the jail time. The jail time of up to 12 months in jail is hardly significant versus the separation from their children or going back to their home country for the rest of their life, where conditions were, in some cases, worse than jail. So if you have a client who has 3 children with a baby daddy and the baby daddy isn't letting the kids go back to Nicaragua with them, there are very few people who would choose to plead guilty and be deported and separated from the children for the rest of their life versus a risk of 12 months in jail if there's a chance at avoiding the deportation consequences. The retroactivity issue, again, is that the law is that Padilla doesn't apply retroactively to cases before March 31st, 2010, but you have to remember that that doesn't apply to misadvice. It only applies to no advice. And it might not apply in your jurisdiction if in your jurisdiction everybody was giving immigration advice for those clear cases. An issue that I see a lot that was touched on by Jonathan is the suspended imposition of sentence. Oftentimes with minor cases, especially drug cases, a judge can give a suspended imposition of sentence. And that is they'll accept a guilty plea. They'll give you some small amount of community service. They'll say, I'll put you on probation for a year. And if you complete all this, I'm going to dismiss your case. And the language that judges are still using in many courts is, and this will not be a conviction for any purpose. So at the plea hearing, the judge says, I'm going to accept your guilty plea. I'm going to dismiss this if you're of good behavior, and this will not be a conviction for any purpose. But that circuit court judge, or that general district court judge, has no idea about immigration law. Because as Jonathan told you, wow, this is a conviction. Not only that, is forget about the few weeks or few months, you're going home for the rest of your life. You're going back to that country that you fled from for the rest of your life. And what you need to do is convince the court that the court will get the same result. Either convince the prosecutor to agree, or if they don't, tell the judge, we're going to do the exact same thing, but we're going to enter a not guilty plea instead of a guilty plea. You'll still make a finding sufficient, right? You'll still impose community service, and you'll still wait to see if he's of good behavior, and then you'll dismiss it. And the only difference here is that we're entering a not guilty instead of a guilty plea. And we haven't had any problems when we explain to the court that's the only difference. Because when he says guilty, he's going to be deported. When he says not guilty, he'll be able to still go to school here, still live his life here. Are there any questions about that? I see that still all the time.
If you plead not guilty, though, and then fail during the interim, then you still have the right to go back and go to trial. And that's, as a practical matter, the Commonwealth's attorneys aren't going to want you to have that opportunity. We're cutting this deal today. It's over with today. And he takes the SIS, completely guilty, he screws it up, it's an automatic conviction. They're not going to want to give him the opportunity to have 2 bites of the apple.
Okay, but you got to get it, and we have, and I've never had a Commonwealth's attorney say to the judge, I've had the Commonwealth's attorney object. I've always had the judge do it. I've never had the Commonwealth's attorney raise that. It's maybe one of the reasons why, but like anything else, who's going to be thinking faster in the feet, and what do you need? What you need is a not guilty. You just can't have a guilty. And sometimes you'll get the Commonwealth agreeing, and then that'll be easy. And sometimes they won't. The last time I had this, and the Commonwealth objected, and I said to, it was Judge Roush in Fairfax, and I said to her, the difference between guilty and not guilty will be virtually nothing to this kid, who is an engineering student at George Mason, except that he'll be deported to Kenya. And the Commonwealth said, made all those arguments. And I said, it's a difference between saying not guilty and guilty. And the judge looked at the Commonwealth and said, I should deport you to Kenya. And granted it. So, I think for most judges, they'll think, you're going to have a misdemeanor trial later. If he fucks up, he's going to get punished. And he better not. But the truth is, this is what you have to get. You have to plead not guilty. You can't plead guilty, so you make the best arguments you can. And if nobody agrees with you, then you're out of luck. The last thing is about cooperating with Habeas counsel. So if you get into the position of failing to give somebody advice or giving the wrong advice and somebody comes to you, this happens to me over and over again, that people mistake a habeas petition to be a lawsuit against them. Remember, and people have filed habeas petitions where they've claimed I was ineffective, and I've filed habeas petitions where I've claimed my friends have been ineffective. Remember, it is not an ethics complaint, and it usually does not end up being an ethics complaint. It is a lawsuit about the fairness of the proceeding, claiming that you gave unreasonable advice. It can end up being an ethics complaint. It rarely does. It can, but it rarely does. It's not a malpractice claim. It's rarely, there was a malpractice claim brought recently in a case, and it got thrown out almost immediately. The woman gained relief for ineffective assistance of counsel, then brought a malpractice claim, and the malpractice claim was dismissed on a 12b6 motion. It's rarely a malpractice claim. It's not a lawsuit against you. Remember, the file belongs to the client. If somebody comes to you and says, you know, this person is suffering immigration consequences, the most annoying thing to hear, and can I get a copy of your file, is, what do you need from the file? Well, I need the file, just give me the file. And that's the way that you would want it to work when you need the file. Give me a copy of the file, or give me the original, whatever you want, but just get the file. The file belongs to the client, and we're way beyond arguing who the file belongs to. There's a recent legal ethics opinion about the Attorney General was in a habit, and Kate, maybe you can fill this in, but they were in a habit when a habeas petition being filed, the criminal defense attorney would often get a letter from the AG saying, we want you to talk with us about the case and give us an affidavit. They would do it in almost every case. I haven't seen those letters recently. There's a legal ethics opinion that makes it murky, but fairly clear that if you are a criminal defense attorney and a habeas petition is filed in which is claimed that your performance was unreasonable, you are far better to discuss the case under judicial supervision rather than just going to the Attorney General or anybody else and discussing without a waiver of attorney-client privilege. Kate, do you have any thoughts on that?
Sure. So I work for the Attorney General. I'm obviously speaking as a private citizen, not on behalf of the office. I think LEO 1859 is not binding. It is, the statute clearly says that you waive your attorney-client privilege when you when you file an ineffective assistance of counsel claim against your trial attorney. I will say I send out letters and I inform trial attorneys that they've been alleged to be ineffective. I think that if I was a trial attorney, I would like to know if someone was alleging that I was ineffective. In my letter, I make people aware of 1859. I also tell them that if they would like a judicial order permitting them to contact me, I'm happy to attempt to get one. So thus far, we have never had in a circuit court a judge refuse to permit trial counsel to speak with us. I think there's nothing barring trial counsel from speaking with Habeas counsel. I would say that I just went to a hearing on Monday where the trial court said, of course, I would like the attorney to file an affidavit in this case. It will make things easier, quicker. We will know what we're dealing with, and we will know whether it's necessary to go to an evidentiary hearing. Because typically what happens with a habeas petition is you are dealing with only the statements of the defendant. There are some cases where trial counsel will provide an affidavit to habeas counsel. That's not in every case. I think it's great if trial counsel would provide an affidavit, I think that would clarify most habeas cases from the get-go. I can't tell you how many cases I've had. In fact, I just had a case come off the docket because trial counsel said, I absolutely advise him of the immigration consequences. The Commonwealth's attorney will back me up, and the petitioner just had not been truthful with his habeas attorney. And had there been communication between the trial attorney and the habeas attorney, they perhaps wouldn't have gotten to that stage, and the petitioner wouldn't have spent money on a frivolous claim, since trial counsel had evidence that he had communicated appropriately with the petitioner.
Let me just touch on a couple of those things. Kate brings up a lot of good points. One of them is there are times, and Kate and I have done this in a case, where I know exactly what the answer is. It's very specific, and I'll say to the trial counsel, give an affidavit to the court that addresses this one specific issue, even when it's bad for me, because it's going to come out, it's just a waste of time not to do it. The reason why the trial counsel can talk to me, Habeas counsel, is because my client is the one who holds the attorney-client privilege. The difficulty with you talking to somebody else is not that the attorney-client privilege hasn't been waived, but what has it been waived to? And I can tell you so many instances where the attorney who has been alleged to be ineffective is so defensive that he takes this broad view and like opens his entire file to the Attorney General. And so it's like, no, we had this one specific claim. If you really think you want to take that seriously, that we've waived our attorney-client privilege for the claims that we've made, you got to stick to that claim. And the real trouble is if you go and you just speak sort of off the cuff to people other than your client and his attorney, if there's a habeas petition, is you are likely or you are at danger of exceeding the scope of the waiver. And that's why I would say LEO, that's what LEO 1859 I think is really about. Everything that Kate said is correct. It's also correct that clients come to me all the time asking me to help them because they have a conviction and now they're being deported. And you all know this, you criminal defense attorneys know this. When you ask your client as a criminal defense attorney what happened regarding the crime, what do you get? You get about 20% of what he told the cop, right? The cop knows 80% more than you. As habeas counsel, when the client comes to me and says, I have a conviction, my attorney didn't tell me anything, is no different from the criminal case. I'm only getting like 20% of the story. And until I get trial counsel's file, until he retains me and I get trial counsel's file and I do all this work, that's when I discover, either you made a mistake in representing what your citizenship status is, or there was a conversation and either you didn't understand or you don't remember. And I have a similar view for these clients that I do for the Farmville folks. I don't think the Farmville folks are evil. I think they're underskilled and underpaid and overworked. And my clients who come to me and say, I never got immigration advice, I think they're rarely lying. I think they're completely confused with the entire situation. All they're thinking about is one or two things when you're seeing that lawyer, and everything else is going over their head. And unfortunately, of course, they are stuck with that. If there's documentation of correct immigration advice, they're going to be stuck with that. The fact that a lot of criminal defendants don't remember the immigration advice is very true, and you're going to be much better off if you give that immigration advice in writing. I've had a case recently, I think Kate is working on it, where the client had no idea what his immigration status was. All he thought was he was legal, and he thought he was a U.S. citizen. And the question is, what burden do you have to investigate the immigration status of your client when he tells you he's a U.S. citizen? And I think it's probably low. It's probably, most courts will say it's very low. If your client tells you what his immigration status, it is low. But Jonathan showed you at the beginning, it's pretty easy to ask in 1 or 2 minutes a few questions. Where were you born? What kind of documentation do you have? And for most clients, you may not do that, but if you have a 19-year-old Hispanic client with a strong accent and he tells you he's a citizen, it doesn't take much to say, where were you born and what's your paperwork? Or ask his mother who's sitting next to him or who's sitting out in the waiting room when he's in the conference room with you. I don't think many courts are going to put much burden on you to investigate that, but I can tell you that I do get clients coming in who thought they were citizens because they thought that's what their mom said, but they were really lawful permanent residents. These are all of them are Hispanic guys between the ages of 18 and 22. I also, in regards to what do you do if a habeas petition is filed, all the lawyers that are most cooperative are always the best lawyers. The best lawyers are the ones who just give me, tell me everything, give me the entire file. They're highly cooperative, and they're not defensive at all, and I'd encourage you to be that way also. And that is it. Are there any other questions? Any topics to be raised? That is as much as you may ever learn about habeas. Thank you.